Cool. Welcome everyone to MyHR's 13th Facebook Live event. Thank you for joining us and taking some time out of your busy week. As you know, today we'll be talking about the Domestic Violence Victim Protection Act, which introduces 3 changes to our laws around employees' rights and treatment of employees by employers who have experienced domestic violence. The most well-known change of which is the paid domestic violence leave, but there are 2 others that we'll be talking about as well. So just in terms of housekeeping, a record of this video will be posted on our YouTube, on our Facebook and our LinkedIn pages, so you can access the content afterwards if you have to leave partway through or if your Facebook cuts out. Do be mindful that this means if you ask a question, it will be captured in the recording, so just be mindful about providing identifying details when you are asking a question. Ask questions as we go. I'll be answering them at the end of the session. There's quite a lot of content to cover off today, so in terms of questions, we might answer them as we go through, but otherwise we'll pick them up at the end and make sure that we get back to you on those. We are trying something different today, so to make this video a more useful resource going forward, I will be using some props throughout the discussion. It should also help if your audio quality isn't that great. Please provide feedback. If it sucks or it's distracting, we don't have to do it again, but it should mean that afterwards you'll be able to flick through the video quite quickly and find the piece that you're looking for. So before we kick off, 2 more things. I do just want to clarify that we will be talking about the changes from an employer's perspective, particularly around managing the requirements the laws, the change in law has required of you. But if you're not an employer, do stick around. You will get value out of this session. We are talking about stuff that most employees will need to know, but just be mindful the perspective will be from that of an employer. Final thing is a trigger warning. If you have experienced domestic violence or there is someone close to you who has, you may find some of this discussion upsetting. So if you are feeling distressed, I would strongly advise that you stop watching the content, and you can contact either Shine, which is a domestic violence charity, on their free call number, or you can also call the Ministry of Health's line or text them to speak to a professional if you need to. Okay, so that's all the introductory stuff. Let's get right into the content. And the question we have been fielding most is, why the law change? What was wrong with our existing domestic violence law, or what has changed to prompt the government to introduce these new changes? So the facts that kind of drive this change are that 1 in 3 women in New Zealand will experience physical domestic violence in their lifetime. That number goes up to 1 in 2 if you include other forms of abuse, not just violence. And this is a national problem with really high costs. So if you include just physical abuse, nationally it's a cost of $368 million a year. If you include all types of abuse, including psychological, that goes up to a $7 billion cost nationally to the economy. So given that these are costs employers will be wearing, we also need to be mindful that 75% of people who do abuse will misuse work time or work resources to do their abusing. So there is quite an incentive on us to be mindful about who in our workplace might be perpetrating abuse. And on the flip side, having a job is one of the most significant protective factors for people who are experiencing domestic violence. So making sure that they have access to appropriate support and appropriate resources within their workplace will help them keep that job, which helps their experience of the violence that they have in their lives. Okay, so that's why the law. We'll now move on to definitions, because these are quite common and quite important when we're talking about this type of law. So the first of which is, what is domestic violence? So domestic violence is defined in law in the domestic violence legislation of 1995, which includes physical, sexual and psychological abuse against anyone whom the perpetrator of the violence is in a domestic relationship with. So these are most commonly romantic relationships, but can be family, flatmates or otherwise. So psychological abuse, of course, includes intimidation, harassment, threats of violence to the person, their family, their pets, coercion, anything like that. Economic abuse falls into psychological abuse as well. So the definition of domestic violence is broad and includes the kind of more stereotypical physical violence, but includes sexual and psychological as well. So you don't have to be blunt, you don't have to have bruises on you to have experienced domestic violence. So who's a person experiencing domestic violence? So there are two different kinds. The first is someone who is having violence inflicted upon them or who has experienced domestic violence before. And the second category is someone with whom a child normally lives and that child is experiencing or has experienced domestic violence. So people who are victims themselves or are in charge or caring for a child who normally lives with them, both of these people count as a person experiencing domestic violence. It's worthwhile noting at this stage too that these new law changes don't just apply to domestic violence that has occurred during someone's time with their employer. The the paid leave, the not discrimination and the flexible working requirements or options to request flexible working apply to anyone who has at any time in their lifetime been a person experiencing domestic violence or been in charge of a child who has experienced domestic violence. So if someone had an incident happen before they started employment with you, they will still be eligible for these new provisions under the changes to the law. Okay, so I mentioned at the start that there will be 3 changes. The first of those changes is the paid leave that I flagged at the start, and we'll be talking about that in some detail. The next change will be the right to request flexible working arrangements of up to 2 months, and we'll talk about that as well. And the last one is that someone who is experiencing or has experienced domestic violence cannot be discriminated against, and they have new mechanisms to seek redress if they have been discriminated against. Okay, so the first of these is the paid leave that we flagged at the start, and it's been the most popularly discussed change under the new laws. So if you're a person experiencing domestic violence or who have had experienced domestic violence, you're entitled to 10 days of paid leave after 6 months of continuous employment, and that is 10 days for every 12 months of employment after that 6-month anniversary. So just like sick leave counts from the first 6 months of employment, you don't have that entitlement. It then hits at your 6-month anniversary and every 12 months thereafter. The paid leave doesn't accrue from year to year, so you won't end up with someone with 20 or 30 days of paid domestic violence leave available to them. It is a maximum of 10 days per year. You can agree that the leave can be taken in advance. So if someone in, let's say, month 4 of their employment applies for domestic violence leave, you can agree that it will be taken from their entitlement. That will kick in 2 months' time. That's up to you as an employer. And the leave must be applied for as soon as is reasonably practicable. So if someone on the morning of their shift applies for the domestic violence leave, and that's as soon as they possibly could have applied for it, then that's acceptable. If someone knows that they have a court hearing to attend in 2 weeks' time related to their experience of domestic violence, then they should apply for that as soon as they know about it so that you can resource appropriately. So as soon as is practicable depending on the circumstances. And just like with sick leave, if an employee is taking annual leave and during that time for whatever reason they need to take a piece of domestic violence leave, then they can swap out what would have been an annual leave day for a domestic violence day, which is the same as sick leave. So that's not a change, it's just a mechanism that applies to domestic violence leave as well. So to cover off those highlights again, it's 10 days of paid leave paid for by the employer, not by the government. So just like employers pay for sick leave and bereavement and annual leave, it's paid for by the employer. It's 10 days for every 12 months. It doesn't accrue from year to year, so it's capped at a max of 10 days per 12 months. It's not paid out to the employee at the end of their employment. Again, just like sick leave isn't paid out to employees. The employee has to apply as soon as is reasonably practicable, and you can agree that the leave is taken in advance, just like you can with sick and annual leave. On the issue of proof, and this is something we are getting asked about quite frequently, so it's top of everyone's mind, the law is really, really clear that you can ask for proof of that domestic violence in order to approve the leave. The law doesn't define what proof is. Of course, that would be far too specific and too helpful. So things like a doctor's or a medical certificate confirming that they have been experiencing domestic violence, a letter from an agency like Women's Refuge or Shine or Shakti confirming that this is the experience that they're having at the moment, something from one of the government agencies, any kind of supporting documentation would count as proof. So be mindful that there isn't a definition for it like there is for a medical certificate for sick leave, for example. Having said that the law says that you can ask for proof, we have done some work and had some conversations with SHINE, which is the National Domestic Violence Agency, around managing this leave. They strongly advise that you do not ask for proof when someone discloses they've experienced domestic violence and are asking for a domestic violence day off. So just to repeat that, you can ask for proof. Proof isn't defined, so we suggest you have it in a policy if you will ask for it. But SHINE's position and MyHR's position is that in the first instance, you don't ask for proof of the person's domestic violence. The thinking and reasoning behind that is this person has, male or female, because the leave and the protections apply to men and women and people of all genders, is that their abuser will already be telling them that no one is going to believe them, and if they come to you and take what is an incredibly brave step to disclose that they've been experiencing violence, asking them for proof is counter to your good faith obligations to work with that person, and it will feel frankly pretty shitty for the person who's disclosed that to you. So the law says you can, you have the legal right to. MyHR's position is that you don't in the first instance, and only if you start to believe that someone might be taking the mickey or that they're being untruthful, at that point you can ask for that proof and engage with them on that front. So that's the leave piece. I'm sure there will be lots of questions about that, which we'll answer at the end if we need to. Moving on to the second change, flexible working arrangements. So currently all employees have the right to ask for flexible working arrangements, and the onus is very much on the employer to make that work if they can. So if you are a person experiencing domestic violence, and just to recap the definition, that's if you are experiencing or have ever experienced domestic violence, or a child lives with you who is currently or has ever experienced domestic violence, you're a person experiencing it, you're entitled to make, or have someone else make on your behalf, a request for a short-term variation to your working conditions, and short-term means up to 2 months. So this can be any of your working conditions. This might be the times that you start and finish work. This might be the location. This might be where your car park is. It might be which bank account your salary and wages are paid into. It might be having someone escort you to and from your car if you need to. Any variation to working conditions is acceptable as a request here. Employers need to respond within 10 working days of receiving that request. Obviously, we would strongly advise that you respond as quickly as you can, because if someone's making this request, they're not making it lightly. And the employer can ask for proof within 3 days of receiving the request, and if that proof isn't provided, they can decline the request. So the language here in the law around employers managing the disclosure piece and managing the proof piece to accommodate the employee who's experiencing the violence are a lot more explicit about employers being able to decline if that proof isn't provided. You can also decline the request if it would have an unreasonable impact on your business, which might be costs that are unreasonable. It would be too difficult to manage the rescheduling of people. Anything that would be unreasonable, you can decline the request on those grounds. So yeah, that's a change that is meant to be quite clear for the employer so that they know these employees can ask for that variation. As always, we would strongly advise that you do try and accommodate that request. The person making it, again, won't be making it lightly, and in good faith, you're required to be pretty proactive about that kind of stuff. The last change, we're getting towards the end now, is protection from discrimination. So if you're an employee who is experiencing or has experienced domestic violence, you are now protected from discrimination under both the Human Rights Act and the Employment Relations Act, which governs all employment relations in New Zealand. So you have the same protection as someone with a religious belief of a particular race, disability, family status, and so on. A person experiencing domestic violence now is a protected category. This means you can't be treated adversely before or during or after your employment with someone, and adverse treatment would include things like not being offered opportunities within the workplace, being fired because of it, not being included in meetings, any kind of behaviour that would disadvantage a person with domestic violence is prohibited under these changes. But this also means, of course, that an employee can raise a personal grievance under the Employment Relations Act if they are discriminated against. They can also raise a claim in the Human Rights Commission. Most of you may not know that claims under the Human Rights Commission often pay out significantly more than they do under the Employment Relations Act if a PG is raised. So there is now 2 options for employees to pursue if they do experience discrimination because they are a person experiencing domestic violence. And the human rights one is quite heftier in terms of potential penalties. So that is a quickfire summary of the 3 changes to the rights of people experiencing domestic violence as far as it goes in terms of employers. We'll run through now and talk about our recommendations for managing this, because it is a sensitive topic and I trust everyone watching wants to do their absolute best by the person or anyone who does disclose that they are experiencing domestic violence. So the first thing to recommend is to have a really clear policy document outlining what will happen if someone does disclose that they are experiencing or that they are a perpetrator of domestic violence, and make it really clear how you'll manage that and what your process will be. For clients of MyHR, we have a policy document we've prepared, so let us know if you would like copies of that. We can tailor it to your business as we need to. For those of you who aren't MyHR clients, hello, welcome to MyHR. And the domestic violence policy is one of the many benefits of being a MyHR client. If you're not ready to sign up, the Shine website, which is the charity I name-checked earlier, has a really thorough policy guideline document for building policies and being mindful of what people's experiences of domestic violence are like. So if you're a MyHR client, let us know. You can email us at info@myhr.co.nz and we'll prepare that policy document for you. If you're not a MyHR client, go to the Shine website and take a look, or sign up to MyHR and we'll take care of it for you. I mentioned this earlier, the next piece of advice or the next position that we have is that by default you don't ask for proof if someone has applied for the domestic violence leave. It would be incredibly disheartening for someone to make that disclosure and then be pushed back because they don't have the appropriate medical certificate or other documentation. It takes on average, this is a stat for women, I don't have stats available for men, it takes a woman on average 7 attempts to leave a domestically violent situation. So if they're at the point of seeking help and looking to reach out as they're trying to change their situation, it would be incredibly disheartening to be knocked back and potentially quite risky. So don't ask for proof. If you do ask for proof, be really clear what will count as proof, which is where that policy document comes in handy. So people know as people managers what they can and can't ask for, but they also know as employees what they may be asked to provide if they do apply for the leave. Next, we would strongly recommend having a couple of people in the business do some reading up on this area so that they can act as the key advisors or key people in a situation where someone does disclose that they are either an abuser or that they are a victim of domestic violence. So depending on your business, this might be your people managers, all of them, you might get all of them to do some training. This might be just the owner of the business. And to name check Shine again, they have some great resources and including fantastic courses for managers around managing domestic violence disclosures, which includes a half-day workshop. So this might be something you as a business owner do, it might be something you build into your training for managers, it might be something that you have a look at, but yeah, we would strongly recommend a couple of people are really prepared to manage this if it does come up. As with any situation, if there is an imminent risk of harm to someone, call the police on 111. Don't wait to call us, don't wait to call Shine. Make sure that you give the police a call if someone is saying that they're afraid that they might be hurt, if you have someone's perpetrator of violence threatening to come to the workplace to harm them or others. Treat all threats as if they are credible and call the police if you need to. They're the first port of call. Next, don't refer domestic violence victims to EAP support or employment assistance programs. The people running those programs are fantastic at what they do. What they do doesn't include support for domestic violence, people who have experienced domestic violence. So don't refer them to EAP. That is a bad thing to do, we've been advised. It can be quite detrimental to that person's experience. So refer them to Shine, offer support internally, but people experiencing domestic violence should not be referred to EAP support in the first instance. There is a free Shine helpline, which was on a prop that I had earlier, and I will pull back again now. So this helpline is available for you as a manager or a business owner to call if you do have any questions. It's also available for people who are experiencing domestic violence and need professional help. It's a free helpline. There might be 5-minute wait times, so please be mindful that there are those wait times there. But they are trained professionals who are there to support you or your business with the questions that you may have. So call them, they're very happy to be contacted. They would prefer to be contacted, of course, so give them a call if you need to. Finally, of course, if you're a MyHR client, you can always call us here to help. There may be times when we consider that a situation is outside of our expertise and we do refer you on to external third parties, but we can certainly help have those initial conversations, prepare policy documents, make sure that you are as prepared as you can be for these changes that hit next week. So that was everything from me. Thank you so much for your time and for watching. I'm just checking with my tech people to check that there are questions, and I'm getting the go ahead, so bear with us as we get those sorted. Thank you.
So we can start from here. That's heaps done.
Oh, there's heaps. Okay, cool. So question from Chelsea. Hi, Chelsea. Is the entitlement criteria the same as sick leave and bereavement leave, and therefore renewed on the same anniversary date? Pretty much. So the anniversary date for sick and bereavement leave is 6 months of continuous employment. On a person's 6-month employment anniversary, their sick, bereavement, and now domestic violence entitlement will kick in and is renewed every 12 months from the anniversary date. So unlike sick leave, it doesn't accrue from year to year, and unlike bereavement leave, it's not tied to a particular event, so the entitlement is slightly different, but the time frame for entitlement and then for renewal is the same. Can you request leave, this is from James, can you request leave to support a partner or family member who has suffered domestic violence? No, you can't request the leave if you aren't the person experiencing domestic violence. You can request unpaid leave under the new law, so you can definitely request time off work. It just won't come from your domestic leave entitlement, your domestic violence leave entitlement. If the person you are supporting is a child who normally lives with you, and the definition of child is age 17 or under and not in a de facto or married or civil partnership, then yes, you can request domestic violence leave to support them, but not if it's a parent or a friend or otherwise. It would need to be unpaid leave or paid leave if your employer has that policy. Another question from Chelsea. Hey Chelsea, what responsibilities do employees have to notify police if an employee is a victim of domestic violence? I take it that means what responsibilities does an employer have to notify if an employee is a victim? None. It's actually a privacy piece if you notify the police on their behalf. If an employee discloses to you, for example, that their partner or flatmate or the person who's the perpetrator of violence on them is coming to the workplace to kill them or to harm them or to hurt anyone else at work, absolutely call the police, treat it like any other threat of violence against anyone in your business. But employees who are experiencing domestic violence have experiences of and feelings of complete lack of control over their situation. Domestic violence, from again my training and what I know, will often start off as a funnel where the behaviour at the top is designed and intended to isolate, remove people's support networks, remove the economic support networks to the point where they are completely dependent on the person abusing them. So making sure that if someone does disclose to you that they are a person experiencing domestic violence, that they have feelings of control and management over their situation is really crucial. That involves supporting them to manage their situation and to make decisions appropriate for them at the pace that they're comfortable with. So you can't notify the police on their behalf if they don't want you to. You can call the police if there's that threat of imminent harm, but otherwise it's up to them to notify the police if they want to and work through whatever the next steps are there, which might include things like a protection order. Question from Nikki. Going through the Human Rights Commission takes significantly more time. Is that likely to change? Hi Nikki, great question. The law doesn't account for extra resources for the Human Rights Commission as far as I'm aware. They may need to assign more resources to the Human Rights Commission. I don't have a read on whether it is likely to take less time at the moment. I'm sure that they will make announcements and press releases if they decide to assign extra resource, but I'm unclear at this stage. Question from Jen. Hey Jen, how are you going? How can we mask the leave on their pay slip? We don't want to put them at risk for reaching out and applying for the leave. That's a great question, Jen. It depends on the business. We strongly recommend in that policy document that I checked earlier that you do prepare or have a rule around how that will be managed in payroll. Some clients we're working with will put it down as domestic violence leave, but their payroll systems are very locked down and only accessible by the payroll team. Some clients will take it off their employees' annual and sick leave entitlement, so it just looks like another day of annual leave or sick leave, but then later discreetly top up those balances so that the employee doesn't actually have annual or sick leave taken off. Westpac Bank, who are one of the larger employers in the country and have the most sophisticated corporate strategy for managing domestic violence that I'm aware of, have a particular code that they apply to domestic violence leave, which is a number that doesn't have any words attached to it. So there are lots of different ways of managing it. In addition to having a policy piece, I would strongly recommend that when you do have an employee tell you that they are experiencing domestic violence, that you agree with them on how it will be managed. Worst case scenario is their abuser or someone who knows the abuser is in the business and will see their pay slips and take action based on that. That's what you want to try and avoid. So make sure that they are comfortable with whatever plan you put in place, because they will know their situation and their risk factors best. So have a policy document, agree with the person. There are lots of different ways to manage it. Can I ask a referee if a potential employee has used any domestic violence leave, or would that be discrimination? I would really recommend you don't do that. Just like you don't ask previous referees or employers if someone's used sick leave. You can ask if there were any health concerns that you might need to be aware of, so that you can help this potential new employee settle into their workplace and manage any risks appropriately. That's totally fine. But if you were to ask a referee whether someone did use domestic violence leave, I would be really, really concerned that would be grounds for them claiming discrimination if they then didn't get the job. As with any application form for new candidates, we strongly advise asking the question, is there anything that would prevent you from completing your duties and fulfilling your obligations to us at all? Or wording to that effect, not me just kind of spinning it off the top of my head. The reason for that is if someone has childcare commitments, if they have church or religion commitments, if they've got hobbies and go surfing at 3 o'clock every Friday, those commitments will all be captured by that question, as would their, it gives them the opportunity to disclose if they've been experiencing domestic violence. Asking specifically about it, I would be concerned would be grounds for discrimination, so don't do that, please. Next question, any advice or thoughts around avoiding domestic violence leave being included in any reporting options in payroll, from Jen again. Again, it'll depend on company by company. If your leave reporting is at a level where it just shows you how many days of annual leave was taken across the business for the entire year, and so it's an aggregate report that just shows numbers of leave days and not who took it, I would think that would be okay. But again, work with the employees concerned to make sure that they're comfortable with how it's managed, and that they're comfortable with any reporting that will be visible later on. Question from Tara. Hi Tara. If your policy states that proof is required, or you feel you require proof at some point if an employee is requesting leave multiple times, and the employee cannot provide proof or does not want to, what can we do? Can the leave be denied? Great question. So if you've requested leave for a day of domestic violence proof for a day of domestic violence leave, you can withhold payment for that day until that proof is provided to you. Again, we strongly recommend that you believe people in the first instance when they do raise a request for a day of domestic violence leave. Research from Australia and Canada, where they also have versions of domestic violence leave, shows that the misuse of it is extraordinarily low, far, far lower than the misuse of sick days or anything like that. So the chances of someone requesting it and not needing it genuinely are pretty low, and the risk that you do significant damage to someone who is asking for it genuinely, in my view, would be too high for me to be comfortable with. So if you request proof and they don't provide it in a particular period of time, I think it's 10 days, you can withhold payment for that day of leave until the proof is given to you, but you can't deny them taking the actual day of leave, if that helps. Question from Shona. Hi Shona. If an existing employee is working for you and has over 6 months experience and experiences domestic violence after the 1st of April, do they become eligible for the paid leave, much like sick leave where you look back 6 months to assess eligibility? So if on the 1st of April you have had anyone working for you for over 6 months, all of those employees will become entitled to that 10 days of domestic violence leave. If you have someone new start on the 1st of April, then you need to wait until the 1st of October, which I think is 6 months after the 1st of April, which is when their domestic violence entitlement will hit. Does that make sense? So they have to have been working for you for 6 months, but the 6 months counts from their start date of employment, not the 1st of April being the start date. Question from Chelsea again. Hey Chelsea, would the 6 month criteria to be entitled for the leave be from, yeah, it's the beginning of their employment, not from the 1st of April. So if you have someone in your business who's been employed by you for 10 years or 15 years or 2 years, that person becomes entitled to 10 days of domestic violence leave on the 1st of April. So the 6-month countdown starts from the first date of employment. Fiona Campbell, hi Fiona. What are the obligations on communicating the change and new legislation to all employees? Great question. So that's governed by your good faith requirements. I would recommend, if you have a smaller business, having a sit down with your team and letting them know these changes. If you're a bigger business, email communication, providing them with your new policy document is satisfactory. So whatever you normally do to communicate changes in policy or changes in law would be totally appropriate. Be mindful that even if you don't communicate it to your team and stay completely silent, 1, you're not being a very good employer, but 2, they are still entitled to the leave because it's a statutory requirement. Everyone in the country will be entitled to this leave if they meet the criteria. So communicate it as soon as you can to show that you're being proactive and that you're managing your communication obligations. Even if you don't, they will still be entitled to the leave. So there's not really any benefit to not communicating it. Not that you were suggesting that, but in case anyone was thinking about it. Question from Jen again. If an employee asks to work from home, do we have a responsibility to complete any health and safety checks to ensure it's a safe place to work, or do we trust that the person believes it's a safe place to work? There are potentially 2 answers to that question, Jen. So if you normally allow employees to work from home for part of the day, whether that's because they're sick or because they frequently work from home, because they're working remote, say from Christchurch, then it would be the same process for managing any other time someone requests to work from home. So if you would normally go into their house and conduct a health and safety check, that's cool, you can do that. If you wouldn't normally do it, then I would say in the first instance, trust the employee's assessment of their home being a safe place. I don't have any data to support this, but I suspect it will be unlikely for people experiencing domestic violence to ask to work from home. They might ask to work from a different location. And if it's a different work location, perhaps because their perpetrator is at the location they currently work, then obviously you're managing that safety piece there. If it is a request to work remotely from a different site, I would follow your normal processes in terms of running a health and safety check and otherwise trust that they are the best assessor of their risk. Question from Daryl. Hi Daryl, will MyHR have an annex or something for employee handbooks, intranets on how to go about domestic violence, and will there be a leave type in MyHR for domestic violence? Great question, Daryl. We currently have a little deployment ready to go for the 1st of April, which will say domestic violence leave in the MyHR leave module. If you as a business are comfortable using that type of leave, that's fantastic. Again, check in with your employee to make sure that they are comfortable as well. In terms of an annex or documents, I mentioned before that we have a policy document ready to go for those clients who ask for it. So if you would like us to send you a copy, just let us know at info@myhr.co.nz and we can start that conversation about what that policy document looks like for you. Cool, so that were all the questions. Thank you so much for your attention and questions as we go through that chat. Again, this content will be available on YouTube, on Facebook and on our LinkedIn pages. I'm sure there are many more questions to come through. Please look at the video, watch back if you need to, flick any questions to info@myhr.co.nz, and thanks again for watching. We'll see you next time.